Welcome to Wills and Living Trusts. How to avoid the three biggest mistakes that people make. My name is John Titone from John R. Titone and Associates. During this webinar, I'm going to teach you how to avoid bad situations that occur in estate planning that unfortunately I encounter too often. Did you know that according to the AARP, the average estate loses 5 to 7% of its value going through probate? Not to mention the potential years of struggle and fighting amongst the family members. I'm hosting this webinar to show you how you can avoid that. Okay, with that in mind, let me switch over to my slides and we can get started. During this webinar, we promise to teach you how to make sure 100% of your assets go to the people you love, how to avoid Michigan probate court, the differences between a will and living trust, why putting assets in your children's names may be a mistake, how to safeguard an inheritance from divorce, lawsuits, creditors, irresponsible spending, and more, how to provide for a beneficiary who receives government benefits. Plus, if you stay until the end, we have a giveaway. Stay tuned. So, as far as a background, I studied at the University of Detroit Mercy School of Law. I graduated in 1996. After passing the bar exam, I was admitted to practice in the state of Michigan that same year. I'm a member of the Macomb County Bar Association, Oakland Bar Association, Macomb Probate Bar Association, and the Michigan Bar Association. I started working at Buffalino and Palazzolo back when I was in law school. After graduating, I continued to work there until 2003. I started my own law firm, John R. Titone and Associates, in 2003, and I've been self-employed ever since. My law firm has offices in Macomb, Oakland, and Wayne counties. I've also been selected to super lawyers each year from 2019 to 2023. This is a peer designation, which is awarded only to a select number of accomplished attorneys in each state. I also own several rental properties that I manage myself. And most importantly, I have 3 children ranging in age from 10 to 21, and I've been married for over 22 years. Also, you'll be seeing a box below this video that says Q&A. If you want to type anything in that box, it will come to me, and I will get as many of these questions as possible answered at the end of the presentation. If I don't get to yours specifically, I'll do my best to answer you directly over email as soon as I can. This is the biggest mistake, number 1, not having any sort of documentation, will, or trust for after your passing. This means regardless of what you want, other people are going to decide what happens to your money and property. It may be a judge, your spouse, a court-appointed administrator, your children, stepchildren, or siblings. This means your family is likely to go to probate court and will have to deal with the fighting, time, and money I've alluded to and will discuss in more detail. With that in mind, I'm going to start off with a story. My grandfather divorced my grandmother in the 60s and then remarried a sweet lady named Millie. Mark was always in incredible shape, had minimal health problems. To be honest, everybody believed that Millie would pass before him. She had diabetes and she had struggled with other health problems throughout her life. Unfortunately, 20 years after they married, Mark passed away from a heart attack. And this is where things start to get really messy. As soon as Mark passed, we discovered that he had no estate planning documents in place at all. This means that my mother, Ginger, and her 3 brothers ended up with nothing. Everything would go to Millie, no matter what Mark wanted. If you think that's bad, it gets worse. Millie passed away years after, and who do you think received all of my grandfather's assets? Her kids, who lived in another state.
Millie did not work while she was married to my grandfather, and all of his assets he worked so hard for went to her and her family. All of their children were grown and moved out of the house by the time they were married. So Millie didn't raise Mark's kids, and Mark barely knew Millie's kids. My grandfather, Mark, had always planned to leave my mother and her siblings with a portion of his estate, but never knew he had to set up a will and trust. This is what makes me so passionate about estate planning. I know that I can make sure families don't have to go through similar situations. I have solutions so that Millie would have been taken care of for the rest of her life, and my mother and uncles would have received something from my grandfather's estate, instead of Millie's children who barely even knew him. So, like many attorneys that focus on estate planning, there are two ways that I can help people. One is in the capacity as a litigator fighting against another attorney to prove whether you or someone else has rights to something that your parents owned. The other way I can help is by helping them plan ahead. When someone plans ahead, there are much easier options to go through, which I'll get into later in this presentation. But first, let's start with the situation we're trying to avoid. The process of dividing someone's assets after they pass away is known as probate. There are different rules for probate in different states, so we're obviously going to focus on Michigan here. In Michigan, you can draft a will or a trust that allows you to instruct your heirs how to divide your assets. Or if there is not a will or a trust, the law clearly explains how your assets will be divided regardless of your intentions. The laws in place are meant to be fair. As you can imagine, there is sometimes a lot at stake financially, and people will sometimes try to do sneaky things to get more than their fair share of a person's estate. We're talking about made-up documents, forcing people to sign things under threat, and all kinds of stuff you'd never dream of. In order to avoid that, you either need to provide very specific instructions in Michigan regarding how you want your stuff to be handled, or it will go through the process to handle it for you. Regardless of your wishes, if you don't have a plan or have a plan that doesn't hold up in court, you're going to go into the default situation, which is probate. That means your bank accounts, your home, your cars, and anything else you have, the estate is going to be handled by a person called a personal representative, who will be chosen by the court if it isn't specified in a will. And that person will be responsible for selling any assets that will be divided. So time is a big cost, but don't forget about the real tangible costs. In Michigan, that means attorney fees, paying an accountant, an appraiser, and potentially other professionals such as a real estate sales agent or brokers. The value of any asset is determined at fair market value. So there are no ways to fudge these numbers. Around here, that basically means anyone who owns land, houses, has been putting money into their retirement account, has a life insurance policy, or even a few nice cars, will need a team of professionals to handle probating assets. Probates can easily eat up 3% of an estate's value for an uncontested probate, while contested probates get much more expensive with the additional attorney fees. In fact, reasonable fees are considered $3,000 plus 3% of the estate if there are no disputes involved. This means simple estates in Michigan can cost anywhere from $4,000 and up. And more complex cases can easily cost $15,000 and up. I have seen contested cases where the personal representative and her attorney charged over $50,000 to the estate. That's all money that isn't going to your family. The overall process of probate takes several months in Michigan. We have to secure court dates for hearings, appoint a personal representative for the will, wait for creditors to make claims for debts against the estate, and anything that ends up being disputed. Sounds easy, right? Well, it can be, when we have a simple situation, but those are very rare. When someone ends up passing away without a will or any record of their assets, the only person who has the full picture is not there to guide the process. New assets can come into the picture, situations with deeds and bank accounts you might never have known about will surface. And any one of these can change what the interested beneficiaries want or don't want. Typically, this will end up taking 6 months in Michigan for a simple probate where everyone agrees, while the average probate case takes 12 months or more. That can be 12 months or more of fighting and potentially without access to the assets of the person who passed away. I have been involved in contested cases that have taken several years to complete. And beyond those fees, one of the nasty things about probate is that Michigan law requires it to be put on the public record, which means all of the assets will be listed and filed with the court, along with documents that shows who is to receive those assets. Everything is filed with the court and is available for anyone to see and make copies. Thus, probate court allows the public to know your business. If you have a mortgage, you'd better believe the bank is going to want to have a chat with your family about who's going to keep paying it. Or if you've taken out loans for anything else, it will be the same story. The last and most important drawback to going through probate is the toll it takes on your family. Have you ever heard a joke about families that don't speak to each other for weeks after a heated game of Monopoly? Well, dial that up to 11, because a probate case is doing that with real money in actual houses. All of the events that I've mentioned in this section are stressful in and of themselves, not to mention the fact that people have to grieve for the loss of a loved one. It is an absolute powder keg of emotions that really brings out the worst in people. You may think you know your family, but I can tell you with certainty, there is no way to predict how they will act when there is money on the table. Probate proceedings can change lives, and it's rarely for the better. When you don't have a plan for how you want your wishes to be carried out, your family will be in a contest of wills, sometimes in a contest of attorneys, like I've seen in many cases over the last 26 years. Families that battle it out in court most likely will not spend Christmas and holidays together anymore, and that's just not something I want to see happen, especially when it's preventable. Sounds like probate isn't the way to go, right? I agree. But unfortunately, getting a plan in place isn't as easy as signing a piece of paper. This is actually biggest mistake number 2, thinking you're set, ready to go with peace of mind. While in reality, you have an invalid will or an unfunded trust and sending your loved ones into litigation anyway. And unfortunately, this is a mistake that attorneys themselves can cause who dabble in probate between their criminal cases and their divorce cases, not to mention all those legal document providers out there that advertise the do-it-yourself method. This is the real reason I founded John R. Titone and Associates, to help clients avoid spending money on estate planning only to end up with a similar outcome as mistake number 1, ending up in litigation and wading through the arduous court process to get things done. Even if you don't choose to work with me, I urge you to use an attorney and to ask that attorney how your planning works. If there is anything you need to do after you sign the documents to make sure your family is protected. I have another story regarding this. Actually, let me give you the rundown. This is a story about why you can't leave these things up to chance. Unfortunately, you'll never know when your time is up, and that's the problem my client's father faced. My client Jessica came into my office after her father, Ed, had passed away. Ed had always been frugal, but he had earned a lot in his lifetime, and he owned a home and had a retirement account through his job worth $600,000. He was also a 25% owner of a lucrative business. Ed had named Jessica as his beneficiary of the retirement account when he was divorced and thought that it would all go to her if he passed, even if he never did a will. After his second marriage, Ed again named Jessica as the beneficiary, figuring his second wife would then get the balance, but did not ask his second wife to approve it. After all, this was Ed's retirement account. Unfortunately, Ed passed away from an unexpected heart attack at 56 years old, and things didn't go as expected. Jessica had originally thought that it would be a quick and painless process, but she discovered that under federal law, since this was a certain type of retirement account, the beneficiary designation didn't matter because the federal law required the spouse to approve a beneficiary designation on this type of retirement account. Instead, the entire $600,000 went to Ed's second wife of 6 years, whom he was married to at the time of his passing, since she never signed off on giving Jessica the money. That's when Jessica brought me on as her counsel. We ended up going into litigation for over a year, and in the end, Jessica walked away with way less than she should have if there was a trust in place. It's unfortunate because Ed truly cared about Jessica, his only child, and wanted the best for her. But Jessica's stepmother didn't follow Ed's wishes. This story shows how important it is to do estate planning correctly and not leave your legacy in the hands of the courts. A cheap solution can easily turn into an expensive one without a proper estate plan in place. I see this happen far too often, and I'd hate to see it happen to you. You might be familiar with one of the many services online that allows you to get legal documents generated automatically for a small fee. These companies are relatively new, but the concept has been around for decades. Before LegalZoom, you were actually able to get a blank physical will at Staples. And some states even provide these as a public service. Sounds like a great plan, right? I'll actually admit it. It is. If you happen to have an incredibly simple situation, if you have no assets and no plans to deviate from the state's system about dividing them equally, these can work out. But the minute the situation changes, you have children or stepchildren, you have a house, you're going to be in a situation that a document may not protect you. By definition, these have to be one size fits all. Otherwise, how could they make these documents fit millions of people? Not to mention the laws are different in all 50 states, but these documents are often meant to fit everyone. Some of these documents are close to working, but close won't cut it here. Small states that you may think of as irrelevant can cause huge issues. For example, one thing you must pay attention to is the name on the last page, but people often forget to put that in. You will see these documents getting invalidated all the time in court proceedings because they weren't updated or procedure wasn't followed to make them legitimate, such as having two witnesses. The worst aspect of this, in my opinion, is that it gives a false sense of security. You think you're fine, but when the day finally comes, you've doomed your family to probate court. Remember when we mentioned that the law was in place to protect people from bad actors? One of the ways it does this by having measures in place to prove that a document is legitimate. Otherwise, maybe a bad apple error could come out of the blue with a document saying that the person who passed away left all the assets to them, and there would be no way to contest it. Any will has to be proven in order to be legitimate with the signatures of witnesses. Some wills are even notarized. An issue that pops up frequently, and one that often happens with DIY or inexperienced lawyer situations, is not doing the witnesses correctly or not selecting proper witnesses. If you don't go through this process correctly, If you don't go through this process correctly, and it can't be proven that the witnesses were present for the signing of the document, it may get thrown out the same way the document for the bad apple heir who wanted everything would get thrown out. And guess where that leaves you? Back to probate court and the state's plan for where your assets will go instead of your plans. We're going to get to what a trust is in a bit. But in short, if you put your assets into a trust, you can avoid probate by giving those assets to your family through the trust. The problem is sometimes people get the trust document, but they don't actually put their assets into the trust. This process is referred to as funding the trust. Any asset must be named and placed into the trust to be passed on and avoid probate. It is estimated that as many as 50% of current trusts out there are never funded, which is a shocking statistic. If this part isn't done, all your beneficiaries end up with is a piece of paper. That is obviously not the outcome people who planned with a trust intended when they spent their time and money creating a plan for their loved ones. Which brings me to the next point. Life comes at you fast, and situations change for both you and the law. Estate law in Michigan evolves, which is part of my job as an attorney to keep up on. Rules that are in place when a will was drafted may not hold up when a law changes, and on average, it will change every 3 to 5 years. And your situation will also change. A new house, a new child, divorce, etc. It's stuff you need to stay on top of. If a plan isn't updated, you might end up having someone who was the best option at the time not end up in control of your estate. A really common thing you'll see with younger people is naming their mom as a beneficiary for a will. Well, what happens when 50 years has passed and mom is receiving government benefits or has passed away? This is the kind of thing a focused estate law practice will be able to help out with. That someone that dabbles in the occasional will or trust usually won't have the time to do correctly. Let's change gears and show you how you can do this right. Biggest mistake number 3 is not so much of a mistake, but an example of how things can go right. I know we've covered a couple of unfortunate stories so far, but luckily they aren't all that dramatic. I have hundreds of positive stories I could tell you, but they just aren't very exciting. And that's what we aim for. This story is about my client, Mary, who came in to see me after her husband, Dylan, had passed away from a long battle with cancer. Unfortunately, she had come to see me to help her with the probate process she was about to go through. Dylan had purchased a cheap will online, and the court had decided that the family still needed to go through probate. After the probate case was over, Mary wanted to make sure that her kids didn't have to go through the same thing with her. So she had us set up a will and trust for her. About 2 years later, she called me. She knew her time was coming to an end as her health was failing and wanted to thank me for helping her set up her estate planning. Not 1 month later, she passed away. Instead of worrying about how her kids were going to pay for the funeral, they were able to draw from the trust, and everything was easily handled for them. They were able to honor their mother with a beautiful service, and within 2 weeks after the funeral, all of Mary's assets were dispersed where she wanted them to go. There were no claims against the estate, no headaches, and no drama in the family. I know this because Mary's son then called me to let me know and also to thank me because he knew how difficult his father's probate case was for the family, but the plan I prepared avoided all the hassle, time, and money. Not a very exciting story, is it? That's what we want. I've seen families fall apart due to an unexpected death, and it's not pretty. We want your legacy to live on and for your friends and family to be taken care of without the added stress of probate. My philosophy on estate planning is that I want everyone who walks into my office to leave with peace of mind. We've gone over a lot of ways this kind of thing can go wrong, but with the right plan and documents in place, you'll be able to go through your life knowing that your wishes will be carried out no matter what happens. Another thing I firmly believe in is that peace of mind comes from the right plan for you. There is no perfect one-size-fits-all estate plan. It's about what's right for you and about creating a plan that works with your family's values. Everyone needs to have legal documents in place, but depending on the amount of assets you have, you might need to consider tax implications for your heirs, and you might even have the option to do more with your money than you thought possible. The first big document is a will. When done properly, with the appropriate witnesses and all of the other stuff we've gone over, a will is instructions to the court on how to divide your assets. Even the most advanced estate plans will include a will. One of the things to keep in mind, though, is that a will still requires your heirs to open a probate case with all of the costs and exposure associated with that. The big hassle you are about to avoid with a will is how your assets will be divided. So assuming everything is done properly and is up to date, you can save your family the conflict of deciding who gets what, the longer timelines associated with hearings, and in most cases, avoiding litigation between family members down the line. You will also dictate who will be in charge of managing, selling, and transferring the assets to the right people. A trust is a much more sophisticated document that gives you flexibility to divide your estate without going through probate. You can put your house, bank accounts, and anything else into a trust. When you put things you own into the trust itself, you are able to avoid probate entirely. Trust also allows you to choose how and when people will receive their assets, which can be a very important thing in some situations, such as if you have younger children or heirs who might need more financial guidance. For example, the trust for my 3 kids gives them 1/2 of their share at 25 and the rest at 30. So they don't have the opportunity to spend it all at once and hopefully are mature enough not to. You absolutely have to get your legal documents in place. But when we're after peace of mind, there are other things to take into consideration for most people. We like to think of documents as one leg of the stool. Whether you're leaving behind money, a house, or something else, Uncle Sam is going to want a piece. The way you set up your documents can have huge implications on how much of your money goes to your heirs instead of the tax man. So tax planning is a second leg of that stool. We also have some taxes that are harder to see. Unless you've been managing to avoid all forms of news over the past year or so, you're aware that we have inflation going on right now. Not having money that's growing faster than inflation means you're paying an invisible tax. So our third leg of the stool is financial management. Let's talk about taxes for a bit. When most attorneys talk about estate taxes, they talk about inheritance tax. Well, currently the federal limit is just north of $12 million these days, which most American families don't have to worry about. But that threshold is dropping by about half in 2026 if Congress does nothing, and could drop even lower if they decide to act. So for anyone near the threshold of $6 million, or even less, depending on how much of a risk you want to take with the actions of Congress at stake, should be thinking about federal estate taxes. It also doesn't mean you don't have to worry about your heirs paying other taxes if you don't have to worry about estate taxes. per se. Let me use the example of the IRA beneficiary trust, which we set up for clients that have an IRA. As you may know, you pay taxes on the front for an IRA, so you don't have to pay them out on the back end as long as you're older than 60. The key word in that scheme is you. There are rules where your spouse can inherit it with the same rules, but once you get a child or anyone else into the mix, it becomes a taxable event. That person has 10 years to withdraw the entire amount of the IRA, which is taxable at their current tax bracket, which could be as high as 37% of the total value. Very few attorneys, let alone everyday people signing up for an IRA, are aware of this kind of thing. This is one of the strategies we use to make sure your heirs get as much as they can. I've also seen clients try to give assets to their kids before they pass, or name their kids on the account, which can also have tax consequences. There is a huge gap in the country today when it comes to financial management. On the one end, you have people who are 100% DIY. If you're saving money, you have your 401k or your IRA and maybe invest it in an index fund or do some stock picking. On the other end, you have the stuff you see in the movies and hear about on the news, hedge funds, wealth management funds, and that sort of thing. Without exception, almost every family with a high enough net worth has professionals taking care of their money. When you have the right team in place, your money works for you. It grows when you're living, and it continues to grow when you're gone. Instead of leaving heirs with a lump sum, there are ways to leave cash flows that continue to pay long after you're gone if you have the right team in place. But for everyday people, it's tough to get access to the best professionals. If you wanted to become a private client of JP Morgan Chase today, you wouldn't get past the secretary on the ground floor of that office if you didn't have 10 million in net worth. For most of the people that are under that limit, you are limited to retail financial advisors. Now, don't get me wrong, we work with financial advisors all the time, and there are some great ones out there. But there's also a dark side to the industry that takes advantage of hardworking people that trust financial advisors with their life savings. Many financial advisors are paid on commissions. Sometimes they're getting commissions on the best product for the client. Sometimes they're recommending the product that pays out the highest. Interests aren't always aligned, except for one case. If you haven't heard of this, some financial advisors are what is called a fiduciary. Fiduciaries are legally and ethically bound to place their beneficiaries' interests above their own. If they break the rules on this, there are very harsh penalties. This is the highest standard for financial management and the hardest one to uphold. So if there's any doubt on the quality of financial services, this is what I always recommend for our clients. Back to the legal part. So do you need a will or a trust? Everyone needs a will. Only some people need a trust. I'll give you a classic lawyer answer and say, it depends. Here are the major reasons I would recommend a trust. If it doesn't seem clear by now, I'm not a fan of the probate process and what it does to families. There are absolutely situations where it could cost more to get a trust than one would stand to lose through court proceedings and legal fees. Based on the numbers from the AARP we went over at the start and others, this number is a lot lower than most people think. It's not just the Rockefellers of the world that need a trust. If you have assets worth over $150,000 on average, it will be much less expensive to have a trust. Now, keep in mind, this isn't the amount of money you have in your checking account today. This includes your home equity, your financial accounts, your 401k and IRA, if you have one. And one a lot of people tend to forget, your life insurance policy, if you have one. Having any of these individually can put you over the $150,000 net worth mark. And if that's the case, I generally recommend a trust. If you own a home, I always recommend a trust because a home is a big asset and oftentimes tied to a lot of memories. It's one of the things that you'll see fought over most in probate court. As we've gone over before, you may think you know your family, but it's very easy to get heated and fight over a home in court, which means more money spent in the course of the probate case. Even if your heirs get along perfectly, you now have a situation where they are joint landlords with the equal split that is in the default in state law. Everyone will have a portion of that home. If they decide to sell it, it's almost inevitable. There will be conflict. One person will end up doing most of the work. One of the siblings will want to hold out for a better offer. Somebody will refuse to sell at all. By using a trust, you can set out specific rules for how you want your home to be handled, who you want it to go to, how you want it to be sold, and who the proceeds should go to. And the list goes on. This is a much more flexible way to set up rules on your terms. One group of people I always recommend getting a trust is people with minor children. There are a lot of reasons surrounding guardianship, which could be the subject of its own webinar, frankly, but something that always raises eyebrows when I bring it up is your kids will be getting everything the day they turn 18. Now, I don't want to make any assumptions about you or your life, but I can say from a personal perspective, I was not at the peak of my fiscal responsibility the same year I graduated high school. If I would have received any significant money at 18, I would have partied like a rock star and been broke by 19. Eventually, I did grow up and become much more responsible. The likelihood of your assets making life easier for your children goes dramatically down if they get it at that age. And the chance of it actually hurting them through poor spending or dangerous habits goes up quite a bit. I have seen an official study on this, but a comparable situation I like to point to people is lottery winners. Over 70% of them end up going broke within a few years, and over a third go bankrupt after getting used to spending the money. All of this can be avoided by setting rules for distribution in your trust. Don't let this happen to your kids. Supplemental needs dependents can be in trouble if they end up receiving assets in a large sum. There are big costs associated with caring for people with supplemental needs or special needs that will last their entire life. In addition, we have state and federal programs to help pay for these. When someone with supplemental or special needs gets a big distribution in their bank account, it can kick them off of their government benefits. They'll end up footing the bill for their own care until the money goes out, and then they'll be back to square one with applying. A much better situation is to get this into a supplemental or special needs trust that can be structured to make sure they have money for care and other things in their life for as long as possible. Now, this is one that isn't super fun to talk about, but a big reason to have a trust. This represents a bucket of people that would be in a bad spot if they ended up getting a lot of money. If you have a child or dependent that has a serious issue, or maybe has had one in the past, money can be very dangerous. We're talking about stuff like drinking problems, drug problems, gambling, bad business decisions, that sort of thing. In some of these scenarios, the best outcome is the inheritance gets wiped out in short order. The worst case scenario can be life-threatening. When a probate or will is settled, the money will be given in a lump sum. But with a trust, you can set up rules as to when and how the money is given. A simple way to address this is by splitting the inheritance into annual or monthly payments. but you can get as complex as requiring stuff like drug tests, full-time jobs, or enrollment in school in order to receive installments. This can turn a nightmare situation into a way to get people to do better for themselves, which is what this is all about. While we're on the subject of problem children, let's talk about another option you might have, which is appointing a trustee. When your estate plan includes a trust, you will need what's called a trustee to oversee where the trust ends up going. In a lot of families, this will go to a close friend or the most responsible child. But I'm sure you can think of some families where a responsible child isn't available. Another thing we see all the time as attorneys in this situation. You have the responsible one set up as the trustee, and on paper, they have all the power to distribute the trust. Unfortunately, that person is also human. So when other heirs think they aren't getting a fair shake, they will sometimes try to pressure the trustee, who might be their sibling in other ways. If the trust is written properly, it will be very hard to change your wishes. But it's a very uncomfortable situation for the trustee. So a great way to avoid this is to hire somebody other than a personal acquaintance to be a trustee. There are fees associated with it, but for a lot of people, this is a great option. So we've gone over how the default rules for Michigan of splitting things evenly have their limitations for a nuclear family. Well, those limitations become even harder to deal with when you have to consider the blended family, as we learned during our first story. The truth is, a lot of these rules were written when people didn't live to the age we do today. Divorce was rare, and remarrying was even more rare. So if you have a blended family or children from a previous marriage, things can get very complicated very quickly, as I showed you in the stories that I shared. When we're talking about second marriages with children involved, almost no two situations are alike. And the default situation with probate almost never reflects the complex real life situation. So if you have a second or third marriage or a blended family, I would highly recommend looking into a trust. I have 26 years of experience crafting trusts that will allow your second or third spouse to be given what is needed, but leave something for the kids from your prior relationships and marriages. People who own a business or are self-employed have a different level of risk than people who work regular jobs. In a word, it comes down to risk. If you take someone like a doctor who owns a small clinic, for example, you have exposure to lawsuits for malpractice, which inevitably come up over time. Even attorneys like me are exposed to this sort of thing, believe it or not. There are a number of business-specific structures that can help out with that, but having a trust in place can stop people from going after assets you want to pass to your family, just in case something bad happens. In addition to this, the default rules of Michigan probate court can make your kids equal owners in your business or any stake in a business you have. Most people I know have definite preferences in terms of who they would want to have a say. So I would definitely recommend a trust and specific planning for that, which is a great segue into what I want to leave you with. We've talked about legal documents through this presentation, and I've also told you some stories. I want you to think about what your story is going to be. What you set up with your plan, or lack of a plan, is the epilogue of the story of your life. We've gone over stories that end with families being torn apart, and if I can help one person on this presentation stop that from being their legacy, I can consider all of this having been worth it. So what is your story going to be? Now let me take some of the Q&A questions that have been coming in. The first one is, I have a will from 11 years ago. Will you take a look? Absolutely. And especially at 11 years, you definitely want it reviewed. The laws have changed. Your circumstances may have changed. We need to update your estate plan. The next question is, who will get copies of my estate plan? By law, you're not required to give anyone your estate plan. I always recommend that you let whoever is going to be in charge of your trust or your estate know where to find the documents, but actual copies are not required. In my process, I actually save all of your signed documents to a thumb drive. So if you would like to, you can print out as many copies as you want, or you can give the thumb drive to somebody you trust who can do that for you, even emailing your estate planning documents to others. But it's a personal choice. There is no legal requirement that you have to give the copies of the estate plan prior to you passing away. The third question is, if we plan on having more children, should we wait? The answer is no. You should plan for those children, or even the possibility of children. What we can do when we do a trust or even a will is we can do a codicil for a will or an amendment to a trust. So as your children are born, we can tweak the trust by adding those simple documents to an estate plan that's already done, which will save you a lot of time and a lot of money. And if you have little children, time and money is very precious. So it is important that you get the plan done now and then modify it as your circumstances change. The fourth question is, one of my parents went into a nursing home. Is it too late to protect those assets? The answer is no. There is a creative way that we can structure things to help your parents and preserve as much of their assets as possible under these circumstances. Again, it's always best to plan ahead, especially if you have elderly parents that may or may not end up in a nursing home. But even if they're in a nursing home, it's not too late. The fifth question here, I don't really have that large of an estate. Do I really need a trust? Again, we've talked about during the presentation the different reasons to have a trust. So an estate being large is not necessarily the only reason to have a trust. A lot of my clients want a trust merely for privacy, so that those documents, their assets, and who they're going to go to do not become a public record for anybody in the public to just come and take a look at. So a trust by itself has a lot of protections that go way beyond how big of an estate you have. The next question is, what's a living will and do I need one? With all of my packages that I do a living will. A living will dictates when your life support should be shut off so that you're not suffering should you become mentally incompetent, or, for example, if you're in a coma. They have the ability with our current scientific knowledge to keep you alive for 7, 8, 10 years. I've heard stories. If you don't want to be a vegetable for 7 or 10 years of your life, the living will is a very important document that gives your family peace of mind, knowing you would not have wanted to be kept alive artificially if there was something there to prevent it from happening. And this document does just that. So if you've made it this far, something is resonating with you, and we are here to help. As I promised, I have a special offer for you. If you received all you need from this webinar, you are free to go. But for those of you who are interested, let me tell you what I have for you. I want to offer you a 60-minute session with me to help you out with getting your assets protected. The truth is, everyone has a unique situation with their assets, family, and needs, and it takes an expert to help make sure you have the right legal plan in place for you and your family. There's no substitute for sitting down with a professional to get this set up. But the plus side is, once you get it set up, you can have peace of mind knowing you and your family will be taken care of in almost any situation. If you walked in the door of our office right now, we would need to charge you $300 to sit down with me or my team and get your situation assessed. We typically charge upwards of $350 an hour, and the session typically can last up to 60 minutes. So we can't offer this to everyone. But since you've taken the time to listen to this webinar and understand what's going on, we're willing to make a special offer for people who are on right now. Now remember, getting documents in place will end up costing money, but compared to what will be at stake in Michigan probate proceedings, as we've gone over in this session, it will be much less. But more importantly, you can't put a price on peace of mind. So click that link to set this up while we still have spots available. And that's pretty much it. I sincerely appreciate you investing your time and energy into this webinar, and it shows how committed you are into making sure your family and the people you care about are all taken care of. It's really a special thing in this day and age, and there are very few people willing to do what it takes. Obviously, you are one of those. Thanks so much for attending. I look forward to seeing you again soon. Take care. Thank you.